Morrison versus NYCHA.
Thank you, Your Honor. Cy Aidner for the appellant, and with the court's permission, may I have 3 minutes for rebuttal?
Yes.
Thank you, Your Honor. The first issue on appeal implicates all motions for summary judgment. If Weingrad continues to hold that the movement needs to eliminate all material issues of fact, NYCHA did not do that here in their motion for summary judgment. They moved for summary judgment saying that they had no notice over any type of defective condition in their stairwell, both actual and constructive, and voluntarily attached to their motion building inspection reports that indicated as early as 14 days before this accident that it determined on its own that the treads were unsatisfactory.
Did it indicate the specific stairwell that was indicated here?
It did not, Your Honor, but that was NYCHA's responsibility, given that they attached those records.
So why does it matter if it's not clear that it even applied to the stairwell that was involved?
Because once NYCHA attaches that document and ignores it, you violate a subsidiary rule of waiting until reply to address a document that the permissible inference, at least that Mr. Morrison's entitled to as the non-movement, is that it negates constructive notice.
Are you saying that that document establishes notice? And if so, notice of what?
Well, that's the underlying issue. It was for NYCHA to affirmatively reconcile that notation that its treads were unsatisfactory before the burden switched to Mr. Morrison to rebut that.
Is there any?
If your theory of this friction friction theory, is that dependent on there being liquid, that the steps being wet, or are you saying just the fact that they're painted would satisfy you? I'm just confused about what your theory is on that.
You need them both, Your Honor, but the theory in terms of notice is cause and create because it is the paint that provides, it's cause and create because it is the paint that provides the platform for the water to be dangerous. I mean, just because you have water on the floor doesn't necessarily make it dangerous, at least in violation of engineering codes that were cited by the engineer. But once you put that paint down, that battleship gray every 3 years, and the test comes back that it is below an accepted standard of care, you have a cause and create angle. Even if we can never explain where the water came from, it's the fact that that paint provides that avenue for the water.
So is it the paint plus the water, or is it just the paint alone?
It's the paint plus the water, but it is the paint that's caused by NYCHA, which is essentially why that floor is in a dangerous and defective condition.
And
Does the
so
notice of claim mention the paint or the friction coefficient?
It does mention inadequate friction, as the appellate division noted. It's in the notice of claim.
Is there anything in the record that shows that NYCHA knew or should have known that it was wet?
There isn't, Your Honor.
Okay, and
There
so
isn't.
if it takes both, as I think you just said in response to Judge
Right.
Singas, why is notice alone, to the extent there is notice, of the paints alone sufficient?
Because it is the paint that violates the engineering standards cited by the engineer. Like I said, it goes back to the issue of you can have
I
water.
thought you said it was dangerous only when wet.
Correct.
And so why don't, I'm grappling with why you don't need notice of both.
Because the real defect is the paint that NYCHA voluntarily decided to apply to those treads.
So when you have something that is dangerous only under a particular circumstance, you only need notice of, whatever that first component is, not the second component, even though the second component might never materialize?
I think so, Your Honor.
And where in the case law would you
Well,
suggest,
I found...
or the statute support
I found
that?
no case where you have dual issues with a particular item and you need notice on both. The engineer's position in the case is that once you apply that paint, you invite, once any type of moisture is on there, you invite a situation where the friction is irrelevant.
But then why don't you have to establish that there was moisture in order for that condition to happen?
Because the paint is perpetually there. And they didn't have
So
to...
it doesn't matter, so you have no burden whatsoever to establish that there was in fact water in that area, and they have no right to notice that there was a condition, the addition of the water.
When the underlying theory is that they voluntarily applied paint when wet became dangerous.
Right, you keep saying when wet, but you're saying that you don't have to establish that it was in fact wet, or are you saying that?
Well, I'm sorry, I missed that, Your Honor, if I may.
You said just the mere application, unless I heard you wrong.
Correct.
Was the problem, that you don't have to establish that it was wet, even though you also indicated that it is, the friction is created with the application of water or wetness.
What I can say, Your Honor, is, I think the answer to that question is yes. I mean, let me work backwards. We do not know in this record, and we'll never know where that water or that substance came from. But we do know that it was dangerous under those circumstances that NYCHA created by virtue of the
And
ban.
NYCHA doesn't have the right to know where the water came from or have noticed that there was water. Is that what you're saying? Yes or no?
Yes, when you apply paint under these circumstances.
But if you had steps that were wet, that's a dangerous condition, right? You
Not
would
necessar-
argue that, right? I mean, I slipped on wet stairs. That's a dangerous condition. But you're saying, would you have to show they had noticed that they were wet in that situation, or no? Because everybody knows steps are dangerous when they're wet.
But not necessarily to give rise to tort liability, right? Once you
You have to
expect,
show they knew it was there and they didn't do anything about it.
not when the theory is that they made them dangerous and reduced that friction by virtue of the application of paint.
But
They
you
made
still
them,
need to-
I'm sorry.
I'm sorry, go ahead.
No, your allegation really is that they made them dangerous by application of a paint that becomes slippery when wet. And I think this goes back to a question you might have been asked by several of the judges. How does that relieve the plaintiff of establishing that the defendant had notice of the wetness? Because it takes those two to tango in this case.
I understand, because there's no authority I'm aware of that requires the plaintiff to prove the duality of two, in what initially is disjunctive but now becomes conjunctively dangerous. Without the paint, you have no case against NYCHA.
But I mean, it's possible, wouldn't you agree, that those stairs are perfectly reasonable and safe when they're dry? People can walk up and down them and not have a slipping accident, at least according to your expert's affidavit. What unreasonably reduces the coefficient of friction is wetness. So I think what you're getting up here is a sense that then if it's wetness that really triggers the danger, where's the notice of the wetness?
We don't have notice of wetness, but our trigger
And you
is that
don't
it's the
need it.
paint. Our trigger is that it's the paint that they knowingly applied.
Thank you.
Good afternoon, Your Honors. May it please the Court, Diana Naiman on behalf of the respondent, New York City Housing Authority. The appellate,
What are you entitled to notice of, if anything?
we are entitled either to actual notice or to the constructive notice of the condition.
Of what condition?
What is
Of
the
the paint or of the paint plus the water?
Good point, Your Honor. In this case, the allegations is that there was some sort of a slippery, unknown substance on the steps. And the allegations is that substance what made the steps slippery. And that is what NYCHA has shown it did not have notice of.
So what he said was, it's just the application of the paint itself is enough. But are you saying, even if, not necessarily conceding that the paint was a problem, you are also entitled to notice of actual wetness at the area affected?
Correct, Your Honor. Yes.
So what if NYCHA had used a high-gloss enamel on the stairs, which is extremely slippery, it's very glossy, has a nice shine, people use it on wood trim, oil-based paint, everybody says you cannot use this on floors of any kind because it is a slipping hazard. And the plaintiff slipped on that when it was wet. Do you need, in that circumstance, to have notice of the water?
Yes, Your Honor. At all times, NYCHA would have to have notice of the transitory condition that made or contributed to the surface becoming slippery.
Well, if the paint contributed to the surface becoming slippery, is that sufficient? So now I've got two people walking down the stairs simultaneously. They're painted with this high-gloss paint. One side has got some water on it, the other side doesn't, and both of them fall down the stairs. In that case, you've got sufficient notice, let's assume, for the paint, but not for the wetness, and so one plaintiff wins and the other loses?
Your Honor, that is a hypothetical that is
Difficult.
difficult, yes, under
Why
these
ask it?
circumstances, because in these circumstances, other than the fact that the paint was gray, plaintiffs or appellants' expert does not present any kind of evidence as to what the steps were actually painted with, and does not present.
That's a different question from notice. That seems to me like you might win on summary judgment or something to that effect.
I'm sorry, what is the question?
Well, that doesn't really, we're asking about notice, really, I think, isn't it? The appeal here is really about notice.
Yes.
And I'm not sure that the expert saying that it's gray paint but not saying more than that really goes to notice. I do think that he says it's inappropriate to use on stairs because it doesn't have a sufficient coefficient of friction. Is that right?
Your Honor, I don't know what exactly he's saying. He's saying that the steps were gray, painted gray, and that the wet condition that he created at the time of his inspection somehow reduced the coefficient of friction of the steps.
So are you suggesting he didn't actually recreate the condition that's claimed to have caused plaintiff's alleged injury?
Correct, Your Honor. And in fact, the plaintiff himself did not know what exactly was the substance, the slippery substance that was involved in his accident. So by the expert creating some sort of unknown wet condition does not replicate the exact conditions that existed at the time of the incident.
If you did have notice, you had notice of the paint, I think, right? If you also had notice that it was wet, would you then have any defense at this stage? If you knew both that it was wet and the paint?
If both factors were in place, that the paint was not just gray, but somehow reduced the coefficient of friction of the area, plus the water, then it would be both an argument of notice and cause and create.
But if you did have notice of both, then you wouldn't have the same argument that you have now, I take it, that you didn't know about the slippery substance, whatever was making it wet.
Under that hypothetical, possibly, Your Honor, but that is not what is happening here.
If I could just ask the question in a slightly different way, because I don't think it's a very remarkable proposition. If plaintiff could establish at this stage that you had actual or constructive notice of a wet condition on those steps as they existed with that paint on it on that day, would you have made a motion to dismiss for lack of notice?
If there was evidence of actual or constructive notice of the wetness on those steps, then no, Your Honor. But that is not the situation here. The situation is
get
that there was no notice of either of the conditions.
Your adversary has actually conceded the point that there was no notice of a wet condition, but he says he doesn't need it. Do you want to address that part of his argument?
I think he absolutely does need notice of both the transitory, slippery, or wet condition, and of the fact that it made that surface slippery when being walked on. So I think notice of both situations is required. If there are no further questions, Your Honors, I will rest on the papers and say that the appellate division's decision and the lower court's decision must be upheld.
Thank you.
Just a couple of brief points. Thank you so much. The adequacy of the engineer's test really is one that goes to weight and not to its admissibility, at least based on this record. And one thing, given that this court has said that this case is about notice, the most important thing is, at least in my view, under Weingrad, is did NYCHA really meet their burden in light of the fact that they did not establish their last inspection, that they used an improper affidavit, that there was evidence actually that that porter didn't actually work that day on page 454 of the record. And ultimately, if the court finds that the burden is not met, It never transferred to Morrison to demonstrate his prima facie case. If the court has no further questions, may Mr. Morrison rest on his briefs.
Thank you.
All right, thank you so much.